profesora de Derecho Público y Estudios de Género de la Universidad Humboldt en Berlín y profesora de Derecho Global de la Facultad de Derecho de Michigan. Desde 2011 y 2023, como magistrada del Tribunal Constitucional Federal de Alemania. Recibió doctorados honorarios en Michigan, Ángel y Susanne, y es miembro correspondiente de la Academia Británica de Artes y Ciencias. Ha impartido clases en Austria. En la Universidad de Susanne se faculta de Derecho Criminal de contar con profesoras y compartir con nosotros y hoy os quiero hablar durante 40 minutos sobre el uso de la separación del derecho constitucional y abrimos a una conversación sobre la
Hola, 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 hola.
Thank you very much for the instruction and invitation. It's an honor to be at the University of Sussane. My first time visiting here. I'm impressed. I think it's your first day here at this university. Is that true? 2013, so don't be worried about
I had the pleasure already to visit the Constitutional Court and to even listen into a hearing at the Constitutional Court, the public hearing on the La Guajira case of the state of exception on Friday. So I have a bit of an impression of the legal world here, but really I have to rely on all of you in a conversation today to learn more about it. And this is my starting point, that this is all about learning from each other. Because I assume we have a goal we share, which is constitutionalism that deserves the name. That's the important part, to inspire and inform and frame and make work democracy, that deserves the label based on a commitment to the rule of law and specifically fundamental and human rights that also do not remain empty phrases, but get a reality on the ground. So what I thought I'd talk about with Natalia Ángel Cabo, who regrettably cannot be here because she's a judge and there's something happening at the court and she has to work there, and that's a clear priority. We thought about talking about two topics which may seem to some of you unrelated. The use of comparative material in constitutional courts, that is national courts. Comparative material meaning not international, but other countries, and gender. And when I thought about what I should say to start our conversation, I also thought like, oh, that's a difficult one to combine. But the motivation of my speaking about constitutionalism, democracy, the rule of law, fundamental rights commitments combines them. In that, I think when we look at constitutional law around the world, constitutional courts, human rights protection, constitutionalism, we see a problem more than a solution. We see challenges more than a perfect state of affairs and just, you know, daily work and this and that, in some cases more difficult than the other, and it's more difficult than that at the moment. In Europe, at least, I think in the United States, in some African countries, in some Asian countries, and I am hesitant to say anything about Latin and South America, but my impression is that it is not totally absent here. There are not only critics of constitutionalism and constitutional courts, because critics are a good idea. This is what courts need. This is what the academy educates you for. This is what you're trained to do. Critics are a good idea. But there are now attackers out there. And this distinction between critique and attack is very, very important. And these people who tend to attack democracy, constitutionalism, constitutional court, fundamental rights protection have a particular set of arguments or topics they use to say, this is going too far, this is not right, this should be stopped, you are overdoing it. You are, not living up to the very idea, etc., etc. And certainly attacks vary around the globe. They are heavily reliant on political context and legal context and cultural context. But this is what motivates me talking about it. After having been 12 years on the German Constitutional Court as a justice in the first Senate, which was predominantly busy with fundamental rights protection, what motivates me to talk about it is that I see variations of these attacks, more or less obvious, more or less direct, more or less dangerous, more or less imminent, all over the place. And these attacks, two topics in these attacks are exactly those topics. One topic is, you are a national court, stay national. So for me, and I have my German constitution somewhere, you swore your oath to the German constitution. The president of the German Republic gave you this job, which is not a job, but it's an honor, and it's a task, and it's an obligation and everything. So stay national, reduce your legal thinking to German. There's a lot there, so it would be something to do, but don't go what I would call regional and global. So this attack of stay as national as possible, or this argument, has its plausibility. I swore my oath to the German constitution. It was the German Constitutional Court. I'm not ruling the world, etc., etc. But at the same time, it is used to limit the capacity of constitutional courts to address the problems of the day, which are often global and not national. And second, it limits our creativity and understanding of solutions to the challenges out there, because many other courts in the world have great ideas. And I think it would be a good idea, and it would be ignorant not to. It's a good idea to look at them. And it is just one kind of nice way of saying, stand back, don't do too much, be shy, go small, as some Americans by now say, go small. Going small for constitutional courts seems to be the call of the day. So that don't use comparative material, particularly in a very famous US-American debate relating to ideas called originalism and the like, purported by a former famous, very conservative, very Catholic, missionary-driven Supreme Court Justice, Antonin Scalia. That argument is out there. Do not use, stay national. And that is used to limit the courts and thus limit fundamental rights protection. So that's the one. At the same time, those very same people, and this is a mixed crowd of people. These are autocrats in Hungary. These are evangelists in some African countries, and I think on this continent in some countries. These are very conservative American politicians, very famous one, the other, Ron DeSantis, by now also famous. They are all using this type of argument. And they're using another one, which is gender ideology. Get rid of it. This term, gender ideology, is already, I think, an insult to what has been done over more than 100 years, in some contexts longer, in some contexts shorter, researching gender as a very demanding concept to describe a world which is gendered. It is reduced in calling it gender ideology to something ideological, as if there would not be research, as if there would not be analysis, as if there would not be rational ways of thinking about it, and a lot of discussions of what matters in what ways, etc., etc. Gender ideology reduces it to this, and gender ideology also is this buzzword in many places around the world to, in fact, say, go back to a patriarchal, heteronormative, pretty traditional way of forming families, of raising children, of running the world. So this buzzword or critique or attack say, courts are overly human rights committed, they do too much equality jurisprudence, they are informed by gender ideology, and they should stop that, is another element of a broader threat to human rights protection. There are more. There's in particular racism, because all of these attempts, populist autocrats' attempts to fight human rights courts and constitutional courts are also based on a anti-migration sentiment, often informed by classical racism, sometimes informed by an anti-Islamic or anti-Muslim type racism. So they come in varieties, that's what I'm saying. But there is a set of arguments, again, some nationalistic, some anti-gender, some racist, that are used in variations around the world to do one thing and say democracy with a commitment to human and fundamental rights. It's so 90s or 1945-ish or whatever the period is you think of. I think in Colombia it would be a little more recent, but whatever. Get rid of that. Let's do democracy another way. Let's do what Viktor Orban, the president of the Hungarian Republic, called illiberal democracy, which I also think is an insult to anybody who ever thought about democracy the real way. Illiberal democracy is a contradiction in terms. There is no such thing as a liberal democracy, I think, but it's the attempt to claim that and say, get rid of that human rights stuff, equality, commitment, gender equality, you know, even worse, transsexual rights, gay marriage, all that, and do illiberal democracy our way, the national way, the Hungarian way, or these days, the Uganda way. Uganda being one of the African countries that just passed one of the most rigid and horrible homophobic laws in the world, but also has severe human rights problems in many other ways and is not a functioning democracy in many regards. So what I try to bring as a picture here is a global, very diverse, coming in variations picture of a movement, a right-winger populist autocrat movement that is threatening what I consider the gain and the common ground and the global consensus on human rights protection, fundamental rights protection, as being a component of working democracy. And this is why these two topics, seemingly unrelated, have something in common, because they're both anchor points for this attack, threat, etc., etc. So what I can offer you is two kind of considerations of how the German court and German constitutional thinkers, whatever, and activists, I would never forget about them, think about those two topics and what we do with them. Just to give you an idea, which it would be one answer, one reaction to this. There are many others, and I would be interested in a conversation to find out not only what you think about it, but whether there are more and what your questions are. So I offer this to you as an introduction, and I hope we get into a conversation. So on the comparative aspect, or the question of how national is a national constitutional court, and how national should national constitutionalism be, the German answer to date is maybe not surprising if you look at German constitutionalism, because German constitutionalism is a paradigmatic never again after 1945 to too much nationalism. After 1945, meaning after World War II, meaning after the Holocaust, meaning after the German guilt and responsibility for those atrocities in the world. And the German Constitution saying, never again shall that happen. It interestingly makes the German Constitution not start with the state, but with fundamental rights. And not start with, as in America, for reasons, freedom of speech. That's interesting. Who's commenting? Whatever. Should I do something? No? Should I continue? Ah, somebody's calling us? Via Zoom, hello? Ah, okay. So, somebody else has an open mic and that's why they, I see. Okay. I'll try to get your attention again. Okay. Thank you for trying to do that. So the idea that a constitutional court is not only about the nation, it is not only about the we, and it's not only about us. For a German, can be embedded in the history of the post-1945 never again, too much nationalism. Allora. Just in case anybody has a specific question, we don't do anything without the text. We are, Roman law trained continental lawyers, so we believe in the text. And what I'm trying to say from a German perspective, this overly nationalism is the never again no, which was the birthday of German constitutionalism as it is today. There's a longer history. There was Weimar, and there was, there were more stories, there were more sources, always more itineraries, more paths taken. But the dominant understanding is after 1905, never again the state first, never again the nation first, never again us first. And yet certainly a German constitution, it has the flag on it, right? But it starts within the preamble saying we are embedded in the world, and it starts in Article 1, human dignity is inviolable, and then says in Article 1, Section 2, we are committed to human rights, as in Menschenrechte, not fundamental rights as in Grundrechte, but human rights as in Menschenrechte, global human rights, that means. So we are embedded in a larger picture here. For Germans at the time, that was a call for acceptance, right? This was not a, oh, we are part of it. This was a, please take us back into the family of nations because we failed big time. So that was a starting point. Yet at the same time, when the court was founded, it had to struggle for acceptance by political actors. It was underfunded. It had no building. And, nobody knew people. There's a famous saying of one of the chancellors saying, "We didn't imagine it that way when the court stopped the chancellor's project to have a state TV." So there were struggles, but at the same time, the court eventually developed a jurisprudence which might be interesting from a comparative perspective because it relates to the use of comparative material. Because we did two things, my former institutional self, the German Constitutional Court, Federal Constitutional Court, did two things. It first said, the Constitution is not isolated. The Constitution is embedded in a context of what we call multi-level constitutionalism, in that there are formally the Constitution, this is the Grundgesetz, our basic law. Yeah, that's it. There's no more constitution out there for us. But next to it is the European Convention of Human Rights, like the Inter-American Convention of Human Rights, which is the regional human rights document for the Council of Europe, and Germany is a member. So there is a document which is very similar to a constitution because it sets the foundations of that broader family of nations. So the European Convention of Human Rights is there, which needs to be considered somehow. And there is the United Nations instruments, which Germany all ratified. I think Colombia is very similar, all ratified. namely the conventions on the protection of socio-cultural rights and political and civil rights, and then the specific conventions against racism, sexism, ableism, and the Children's Convention, the more recent ones. So the court said, yeah, this is my starting point. All there is, everything has to be anchored in that constitution and only that constitution, but that constitution opens the door, offene Staatlichkeit. That's an open statehood concept. The state, which was utterly nationalistic, is an open state in that it invites other normative grounds to its understanding of itself. And this openness to others opened the door to now international law material. That's only international law. There was a second opener, big one, the European Union, which is a different type-ish thing, sui generis, of its own kind, in that it is a treaty-based, semi-federal, we don't know, we constantly discuss thing, but it also has a constitution in the treaties and a constitution in the Charter of Fundamental Rights. So again, Germany in the starting point, but things next to it, thus Germany embedded into this larger family. And what is then most interesting is the German Constitutional Court thought from the beginning, you know, we're new on the scene, in 1951 founded, and then eventually, you know, gradually developing with 12-year terms for each justice. So every time a new justice comes, we're pretty new on the block. So, you know, we better look at how others did it, namely the Supreme Court of the United States of America. I would sadly state then really the icon out there, now in a problematic situation and not anymore the model for the world. At the time, also the French court to a degree, because the Conseil Constitutionnel in France is a little bit different. It's not a specialized constitutional court. The Supreme Court in the United Kingdom did not yet exist as a constitutional court, so there was no looking at that. The South African court was founded later, and interestingly came to Germany for a one-week workshop to study how the Germans did it. So we couldn't learn from them, they learned from us. We were happy to share that knowledge. But at the time, particularly the Supreme Court of the United States, then Canada, Israel at the time, the Supreme Court of Israel, were all sources of learning quickly how to do it. And so in the beginning, you find rulings, very few that is, on freedom of speech in particular, because that's a very North American fundamental rights protection line, where the German court cited to the Americans and gave a source in the ruling saying, we do this and that, see, United States Supreme Court, blah, 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 and see, blah, blah, blah. That was taken as borrowing authority, right? That new little German court of that failed country looked at the grand Americans and said, you know, we're in a team with them. we think the same way. So that was a backup. Then we kind of stopped doing that. And these days we took it up again because there's a more intense conversation on comparative constitutionalism and started using publicly in the rulings comparative material from South Africa, India, Canada in particular, one of the closest jurisdictions to us, although it's a common law jurisdiction, but one of the most interesting, France, Belgium, Ireland, etc., etc. Certainly the Strasbourg Court in the European Human Rights System and the European Court of Justice. So many courts, including comparative material. And it was not only anymore, you know, we're new on the block because we're not new on the block anymore. We are now adults, we think at least. There's somewhat, and as I said the other day, Ruth Bader Ginsburg, the former judge at the American Supreme Court, cited a study saying we're the most cited court in the world. So we better live up to that responsibility. We feel very adultish, but we also feel very challenged by that responsibility. So we better also look at all the others because they're gonna use our rulings. So we better know what we're doing because it will have effect on their rulings. And now we cite a little more global. And what you would not see when you read our rulings, in every case we deal with, we look at comparative material behind the scenes. That is, our clerks, our academic assistants, research the seminal rulings from all other continents. Language barriers apply, but most publish in English. So, and there's a requirement to know English, so we have access to some of this. And so I have not seen a single treatise of a big case without a chapter on comparative considerations. Many of those don't go into the published ruling. Why? Well, for the acceptance in Germany, it's often a better idea to say, oh, we're so German. So we're catering a little bit to the critique, which is a little bit, it's also a conversation in the court, but I can assure you, we look at the comparative world. So what I describe here is we're doing it, but we're also reacting to the threats and the attacks, trying to work around it and gain acceptance, etc., etc. Whether that's wise or not, I'm not sure. There was a controversy at my court. There will be a controversy in the future. But that's the part of the comparative material I want to share with you. And if there are further questions, I'm very happy to explain more in how we do it and what we do there. So that's on the comparative part. The gender part is a little more tricky, because the gender attacks on courts come on different levels. So one comes on when a court starts adjudicating equality and takes it seriously and applies it to gender relations, people start being really nervous. Some are annoyed, some get angry. Why is that? It's my favorite question throughout my life, by the way. Why is it that people react to feminism or gender equality or sex equality rights so, well, it's personal, or feminist slogan, the private is political. And it touches people's lives in ways which is different from free speech or freedom of assembly or election rights or whatever. Because it's all about you, me, us, at home, my children, my parents, myself, my love life, whatever, even my body, sexuality. All these things lawyers are not necessarily totally super trained to deal with coolly, rationally, easily informed, etc., etc. So gender is charged, that's what I'm saying. And sex equality rights, which are part of every constitution in the world, I think, our United Nations guarantee, our European standard, our Inter-American standard, are charged with all those, not only personal feelings, but also political controversies and political backlash. And the German court is difficult to describe in that matter, because it was, throughout the 50s, 60s, and 70s, the driver of gender equality in Germany. The Germans, I don't know how many of you have been in Germany, know Germans, whatever, I'm biased, I'm German, I think are in some ways progressive and tolerant and very equal, and in some other ways very patriarchal and very, I don't know. So in the beginning, 1950s, 60s, 70s, they had a family law, old style patriarchal. The man decides in case there's a disagreement, the woman has to ask permission before she can go to work, all the old patriarchal baggage. The court had to do away with it, not parliament. They didn't do it. They had a constitution. They committed themselves to it, but they didn't do it. Well, the court had to do it. So the court was a good court for gender equality. Well, then came the more difficult cases. So the family law had been, marriage law had been equalized, family law had been equalized, but then we come to tax law, where it really matters, because it's money. It's the economic status. It's really interesting. Then we come to equal pay. There was not a single case of equal pay in the court. We get almost every topic, but not that one, until my last year, where I was the reporting justice on an equal pay case. Very difficult, whatever. So there are issues that have been solved, but there are other issues which are still complicated. And the court confronts these issues now in a time when, somewhat carried via the United States debates, the society, the lead media, etc., discuss gender ideology. And the court is not on an island. The court notices that this topic of sex equality, women's rights, moved into gender ideology, weird things, not to be touched, intersexual people. What is that? Transsexuals, is that transgender rights, etc., etc. That was the development, at least in Germany. And many of these allergies I'm trying to describe are imported via US discussions, culture wars, bathroom wars, things we don't have, but they are transported to us via as cultural topics. So what did the court do before my time, I'm happy to say? It started a line of jurisprudence, particularly regarding transsexuals, where it was totally clear on saying, if there's a group in the world that needs a constitutional court and human rights protection, then it may be that group. Why is that? Small group never will have the political power to gain a majority to care for them in the regular workings of a political system. Second, a group that has been demonized and pathologized in that they've been called sick and different and very denounced in public. So a group that carries stigma and stereotype to a large degree, and thus needs a rational institution to say, get away with that stigma stuff, look at their lives and give them the same opportunities in life than every other person in the world. So these two factors made it clear case for fundamental rights protection. And at the time, the court was a court which is, by the way, deliberately half conservative and half liberal and a little progressive. That's our composition. The court unanimously decided, sure, these transsexuals have rights. From a gender perspective, you could also say, however, that it was an easier case because with transsexuals, the case was at the time, people wanting to be the other sex. That is, it did not challenge the binary gender system. It was people born in the wrong body, wanting to move to another body, or wanting to be called the other name, but it did not do away with the men and women marry, and men and women, da, 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 da. So it was complicated in one way, but also not so complicated and not so transformative in another way. But a strong line of jurisprudence, we're very proud of this. Then came, in the last 10 years, other cases. Intersexual rights, most people confuse transsexual with intersexual. Intersexual is this smaller group of people who are genetically, medically, etc., diagnosed as neither male nor female at birth and develop very differently throughout their lives. Often it's found out much later. And they came to the court and said, you know, we don't fit a box. Could you please force the state to create a third box for us? Because in Germany, you have to register your gender at birth. And we said, totally easy case. There are two boxes, you don't fit the box, there needs to be a third box. What's your problem? So it was, again, an anonymous decision. All my conservative colleagues subscribed to that decision. To me, it was a little bit of a surprise, but whatever. They're grand people, they're rational jurists, they're wonderful lawyers. So we had the third sex decision. The third sex decision, however, in the public was taken as, gender ideology in Karlsruhe, which is the place where the court is located. Gender ideology now informs the Constitution. That's going too far. We took that transsexual thing. We took sex equality in marriage and family law, but that is too much. And why is it too much? I'm sorry to say. Well, part of it was because I was there. Because I'm a feminist. I have a professorship in public law and gender studies. I was a feminist activist. My dissertation is on sexual harassment, a comparative, totally legal analysis, but sexual harassment, what a topic at the time before Me Too. Then I think I was part of a movement creating a domestic violence protection law. And I was part of a movement criticizing pornography as sex inequality and not as an issue of morals or your bad or not bad taste or your sex drives or whatever. So that's what many people call a radical feminist. And I was labeled a radical feminist in the papers when I was elected to the court. I think for most people, it was even more problematic that I did not lie about my private life. Meaning, my wife sits here. That's why I'm laughing. I was, I think, around the globe, the first lesbian woman, out, that is, lesbian woman, not lesbian, out lesbian woman, to be elected to such a position. That, for many people, was like, officially, we're tolerant, unofficially, going too far. And so they combined their homophobia and their patriarchal dreams and their being nervous about all those changes in their private lives because of feminism and equality and all of this with a attack on the court, anchoring at my person to say, you know, going too far, gender ideology there, this is ideology, not law, you're not rational, you're irrational, etc. And all the old classic, you know, anti-feminist sentiments going. And it was then not only, they also targeted a colleague of mine who was not a feminist activist before she went to the court, who was not there. And they started going at her, and they started going at my conservative colleagues and challenged them at their public talks, saying, how could you sign on to a judgment where she did not, where the ideology was there? Should I stop or stop? Okay. And so these gender attacks took hold at a moment in time when it was not the classical cases anymore, but they blow up big. They use one little case and they blow up big. I think abortion cases, and I think there has been controversies in these countries, are the other category which are most likely to blow things up. We have a pretty conservative jurisprudence on abortion in Germany, a kind of a compromise, but a very liberal practice around reproductive freedom. And the court has not faced a decision yet, so I don't know from my experience at the German court what happens in those regards. But I know that the people who attack courts because of too much gender ideology also often attack reproductive rights jurisprudence. So that's another anchor they use. So this is how, from my experience on the German Constitutional Court and looking at the German Constitutional Court jurisprudence, the topic of gender and the seemingly unrelated topic of going comparative and going international and going global connected, in that you could now research in German legislative material and political documents statements saying this law is introduced to counter the jurisprudence of the Federal Constitutional Court, where justices like Susanne Baer and put gender ideology to the bench and is going too far, and they also are way too friendly to international human rights material, and they misread it, and they should go more national, and they should basically, you know, stop being so activist or creative or progressive or whatever. This is how it merged in my experience. Certainly, again, there are more aspects to these attacks and more aspects to these drawbacks, but these are two I would want to name and bring to you just as one experience in what I call the varieties of constitutionalism around the world. And I hope with this that I put something on the table or those benches in front of you to start a conversation, and I thank you for your attention and coming and listening and having me here, and I look forward to what you contribute to our discussion. Thank you. Sure. Yeah, break the ice, anybody? It depends on the question. Mostly I'm now pre-trained in Colombia. The questions I got today were wonderful, excellent, and for me challenging, so I better, but we'll see, okay? Good.
I will do my best to contextualize the question as best as possible, because we have about the Constitutional Code of Colombia. You went into the La Guajira case, which is one of these cases that are interesting in both, which is this particular doctrine from the Constitutional Court of Colombia called the Constitutional State of Affairs, which is very close to the structural cases from the U.S. From the U.S. Supreme Court. And I have two questions about this kind of cases. The first one, I'm just curious to know how these kind of structural cases arrive into the court and how they solve it, and how does it work in the in the German Constitutional Court. And second, in my doctoral investigation, I'm very interested in cases in which these structural kind of cases create a context in which the Constitutional Court is impairing or specified by their own remedies. In particular, I'm examining the situation of the prisons in Colombia. One of my hypotheses is that the remedies from the Constitutional Court are so big and so vague and so macro that creates a context in which no lawyer can no longer create new doctrine or create a particular remedy to push such a transformation through the use of courts. So that's
because the remedy is already there, yet not implemented, but you cannot ask for more. Is that the point?
Ask for more. I cannot ask for the review from the remedy because it's one of these macro cases.
I see. Okay.
Yeah.
Okay, that's one of the very fascinating, I think, constitutional topics here in Colombia for me. It's not easy to find the direct comparison, but in German constitutional law, there are two segments, two elements that might be of interest. One is the element of a situation becoming unconstitutional. So these are usually things we have decided, whatever, 10, 20 years ago, even 5 years ago, and the reality changed, and we have to readdress the question, and we'll come to a different conclusion. So the standards didn't change, but the world rendered a law that was all fine 5 years ago unconstitutional because the reality changed. And in some way, that is an unconstitutional state of affairs, but the historical element is decisive in that it was it was created or argued to give the court the power to revisit an issue and respect precedent and not call it overruling because we don't change the standards, but call it kind of new application or application to a new set of facts. Although it's exactly the same problem, the case had even the same name. So that is, I think, a little similar, and there's very established doctrine that when reality changes, because it's all about applying a norm to reality, then we go into it again and we have to reconsider, and everything is open again. So even remedies are open again. You know, it's a new case. And that is the one. The more interesting one, maybe the one which we call the reaction of state inaction to state inaction. It's the total exception to the rule. The Constitutional Court should not replace politics, so it will usually not act. Many people complain that the state is not doing enough. The state in Germany, meaning the legislature, which is, because it's a parliamentary democracy, slightly different in terms of the actor you have in front of you, but we call it the state, or we talk about the government because the government is formed by the parliamentary majority, and so it's the government plus the parliamentary majority. So if they, many people say, you know, you don't fix this problem or that problem or that problem, which was particularly relevant in the climate crisis. Many people, I think personally, rightfully say states are not doing enough. There's a Paris Agreement even, which is not doing enough, but even the Paris Agreement is violated by many, many states. So you better get your act together, particularly us, those nations who use a lot of energy, way too much energy. So in those cases, that was a big argument, and people thought that's also the focus of the case, that the climate crisis cases challenge states to do more based on the argument that they're not doing enough or doing nothing to really prevent us from going down the drain. And the court said and applied a very established doctrine again that no, I mean, you might be unsatisfied. You might think it's not enough. You might think it's, you know, not the right method, the right instrument, that blah, blah, blah. But you cannot say the state did not do a thing. In Germany, it passed a law. Most people thought that, you know, but it passed a law. So the court says, I can only order the state out of the blue if really nothing happened first. it's outrageously evident that there is a serious problem that can be solved by a state. That is also an important link. Or that the state did something which is utterly and obviously unsuitable to solve the problem. But it's a very high hurdle. And in the climate, even in the climate crisis, we said, and I said this in the court, the difference between me as somebody at the election booth, I would have said, wow, the state is not doing enough. It has to do this and that, but that's my political mind. As a judge, I had to say, there is no constitutional case. You will not win your argument because you may say it's wrong, it's not enough, but you cannot say it's nothing. So we will not intervene. It's separation of powers, big time. We will not intervene. However, on the climate case, we found another pretty innovative route in saying young people have a right to liberty in the future. Intertemporal liberty protection. And this intertemporal liberty protection says, regarding the climate crisis, a state can not only act for the voting constituency of the day. It has to take care of those small children. That made the case, but that's exciting. So on the state in action, exception to the norm, because otherwise the court would become a political actor. And so high hurdles. Is there a case where we applied it, where it was successfully applied? I think, but I'm not totally positive. I think we did it regarding nuclear power plants, because there is a jurisprudence on risk technology that if companies introduce risk technology, the state has to take care of precaution around it. I think there's jurisprudence out there, but I would have to research it myself where we really did it. I only know the standards are so high that it almost never succeeds to this state in action. But again, an unconstitutional state of affairs is nothing where we would immediately say, oh, how weird. No, it exists. They're just different access routes to address it. And that was the other question on the access routes. In Germany, there is different from France, the Supreme Court, the European courts, et cetera, the individual constitutional complaint right from the beginning. We are a citizens court, a little bit similar to tutela, but I think not the same, not exactly the same, but it makes the court similar in that regular people without a lawyer can write a little piece of paper and send it to the court, and it will be a case. And each and every little paper will be decided by at least 3 judges, and they have to be anonymous, and most of the big cases are by 8. So that's the typical access route, and we get many complaints by individual citizens saying, oh, it's an unconstitutional state of affairs and please do something, and most of them fail. They're inadmissible because they don't even tell us enough of what they really think about it. The other more powerful but much more rare access routes are state organs can come, members of government, members of parliament, political parties, states like regions in the state can come, but they would never raise such an issue because they themselves would be subject to responsibilities. So if unconstitutional state of affairs questions come, they come from individuals via the individual constitutional complaint. Finally, that is a very interesting concern whether a court can, if I understood it correctly, petrify itself by overbroad or by remedies. It is a concern, I think. I would not have been able to put it that well as you did. So thank you for that. But I remember that when we discuss remedies, it is a concern for 2 reasons. In that the one is we want to be realistic. So it's not directly proportionality, which we are totally in love with, but it's a realism check when we discuss remedies that we cannot overburden politics because we would lose our legitimacy. Our concern is not them. Our concern is us. If a court says, do this and that amount of time, and it's simply not realistic, the court is the loser, we think. because the court then renders empty promises. And that's not a good idea. There is a symbolic value in deciding, so it's not for nothing, but we are concerned about that. Because we are total rule of law believers, and there's a law, and the law has to be implemented. If it's not implemented, it's worthless. And so there was one. So that's one concern, realistic. The other one is, which is mostly brought by professional judges. We have at least 3 professional career judges in each Senate. What they say is incremental progress is progress. Decide one issue at a time. Don't close the doors for different types of constellations, cases, concerns, different voices out there. So we are in some way, I think, courageous and okay in human rights protection, but small in framing the scope of where we intervene. So we do not take the occasion of the case to then finally, plow the field, but really go narrow in remedies and only remedying that very problem and situation that was brought to us in admissible terms and So often in cases like police law cases, security law cases, we said, this is the problem, expose standards, big, 100 pages, and then remedies small. Clause 2B, segment H was the unconstitutional. And people thought, like, why did you go through these 100 pages if you do this small? Well, the 100 pages are the signal for next time. They will read it next time. But the remedy is catered very fine-tuned to the exact case, because the professional career judges always said, well, the next place will come along. You don't want to bind yourself, and you don't want to have anything on the ground which will foreclose room to maneuver in the future. So I think these are the 2 things which come to my mind. Yeah. Please.
One question about the use of comparative material. And it's perhaps I'm curious about how it actually works inside the court, and you can say a little bit more, because as you framed it, actually there's there's a discussion or debate around whether you use it or not. Right?
Yeah.
But for comparative law scholars, maybe the other issue is how you do it, right? Like whether you are a comparative law scholar that you can do it. You mentioned the language restrictions, but there might be other things that are playing up. For example, if you have colleagues on the court who think that the distinctive in common law and civil law are relevant, then you'll be looking to other places. If you think that maybe the global south has something to say about this trend of global constitutionalism, maybe they're looking to other places. So I guess that there's also a debate of how you do it within the people that are agreeing to do it. So I wanted to know a little more. How's that playing out? How legal culture, language, how perception of where to look at also shapes how you do this comparative work.
Yeah. Thank you very much for the question. And I would say the Federal Constitutional Court of Germany is on the way, right? So it's constantly developing and trying to get better, because it's not a long tradition. It's not taken for granted. It's an effort. It's an effort also because many of my colleagues were a little older than I am, thus not trained in comparative analysis. They had not been exposed to this. So it's even from the technique, how you do it, if you are totally familiar with the database, it's easy to research that. If you have never visited that database, it will be difficult. So even to find, technically on the ground, to find comparative material for people who have not done it is not easy. So one thing we do is we have trainings. I designed a training workshop for what we call the clerks. They are fully trained judges, actually, who work as assistants for us. We have very few compared to Colombia. I had only 4, but each justice has 4, and so we introduce training workshops for them to get acquainted with the database and the basics of comparativism. That is contextualize. That is check the translation. That is so when I get a treatise of a case, I got the source, but I usually also got the link to the original, because particularly Spanish and French, many people in Germany, many people know French at least. So to allow us to check for the original version is very important in those matters, because the research was usually focused on decisions, right? So it's not research on legal fields. We didn't want to understand banking law in Somewhereland, but we wanted to understand the Constitutional Court decision on banking law in Somewhereland. So it was court decisions, which makes it a little bit easier because there are also 3 or 4 great databases in the world. There's also the Venice Commission, which is a subcommission of the European Council, which collects cases, which also installs a mechanism where courts can lodge a question. We could send a question to the Venice Commission and to another body, and it's an open call for all courts in the world to tell us what they did on the issue. It's a very interesting device. And the European Court of Justice, the EU court, also introduced a huge database for European case law. So it gets easier by the minute, but it also gets more challenging because there's more material out there, so you have to navigate the material. So training was one, getting accustomed to the type of material, to that type of research is one, and to train or to sensitize for contextualized comparison was the third. Interestingly, the common law, civil law distinction is not very present, to say politely. I would think it doesn't make a lot of sense to me in most comparative constitutionalism analysis. There are the dealing with precedent and the style in arguing differ across the world along other lines, I think. The global South, global North, global West, global whatever that is, challenge is very new to the German scene. There's very few scholars who have addressed that problem that is in German and in the German discourse. I tried to, well, whatever, or there was in the last 3 years quite an intervention to become more post-colonial in our thinking, that is to decolonize our own curriculum. We are at the baby stage there. But depending on topic, particularly regarding climate protection law or climate crisis law, we looked intensely at Colombia, Ecuador, and some others. And regarding reproductive rights, the Colombian decision was very, very intensely read and discussed. And regarding some other topics, we look at to South Africa or India. So there's first steps. There's not enough yet, I think, but that's what we do. There is a discussion of cherry picking, and there's the discussion I mentioned before of what happens if I render a German Federal Constitutional Court ruling and cite as my prime source Colombia. Some people might have a little prejudice in their mind. Some people might think, what, why them? Why not Belgium, Ireland, the ones closer to us, members of the EU? And that there is a plausible argument there. And I think the further you go away from your own legal context and legal culture and legal tradition and legal frame, which is a formal frame, the European Council, the European Union, and all that, the more arguments you have to make sure. But we did throw some little global South remarks there. And I can say that particularly the Colombian jurisprudence is gets way more attention than most other global South countries in Germany. That court is of particular interest because it's perceived as courageous and as creative and as responding to a global problem and facing all these challenges right now. How does a small little court respond to a global crisis? We had this in the pandemic, we had this in the financial crisis, we have this in the climate crisis. So it's a question for all of us, and the Colombia is very inspiring. But baby shoes, I would think. Please. Oh.
And after the
I think that is a I think that is a true challenge these days and for the future, that for a long time, I think comparative constitutionalists were on the forefront of human rights protection. And anybody who did comparative constitutionalism and human rights, et cetera, was like on the progressive side of things. That's different now. So now you can have not only the nationalists being very non-protective of fundamental rights, particular minorities, but you also find comparativists who would say, you know, let's do it like Hungary, who say it's undignified to be a beggar in the street. And beggars in the street do not deserve fundamental rights protection, which in my understanding of fundamental rights is outrageous. Or the Polish court that said, we won't follow the European Union requirements because we think whatever national identity, et cetera, and cited Germany to back this up because we had a critical ruling of European financial stability politics, which I think was a misquote, but that misuse of comparative arguments is very much a trend in Eastern Europe in particular at the moment. So there's negative comparativism in some way. And the American Supreme Court, which I mentioned before, I think for many people in the world who engage with comparative considerations, is a real challenge these days, because it is so politicized, it turns so polarized, and the arguments are often so ideological that it does not serve as a very good example anymore for an institution that has to seek common ground, that has to seek solutions and arguments that are convincing to many segments in society, et cetera, et cetera. So the overruling of Roe v. Wade to many did not come as much of a surprise, but the radicalism in it, and the litigation strategies now going on, and the other, you know, step-by-step takings away of not only fundamental rights, but particularly election rights and political standing, they are very worrying. And they will create a challenge to the idea of constitutionalism, in that people will say now, why should I do this? You know, it's all political anyways. The way it depends on who you put on the court. It's not an idea, a concept, deeply embedded, democratic, et cetera, but it's this, you know, just one other institution. Pick the court, pick Congress, pick the president, pick whatever. And so the whole idea is going down the drain. And since it's the United States and not some small country somewhere in the United States with all its cultural and academic and it's not to be overlooked. So I think that Roe v. Wade, the overruling of Roe v. Wade, generally for comparative constitutionalism is a big moment, and a very problematic moment. And I did not even start addressing what a tragedy is. It is especially for young and underprivileged women. And usually I would start any consideration of all these developments with who's hurt. And those thousands of girls really on the ground hurt by this jurisprudence would be that is like a drama of sorts. I think that is also why the Colombian ruling was very important, and any ruling now in the future on reproductive rights would be very important because that is a global kind of debate and controversy going on there. Overruling generally, to me, is also the total exception to the rule. When I came to the court, I was not happy with everything I found and my predecessors had done, but I would be very, very hesitant to overrule anything because consistency is a high quality of a court. And they had thought about it. They have not been stupid, et cetera, et cetera. But we did overrule one case. It's the only instance in German jurisprudence, which is the case from 1956, where the court held that the criminalization of homosexuality, of male homosexuality, is constitutional. And they were all wrong. They were children of their times, as people say, but they were all wrong. And we overruled that. And my conservative colleagues were strong forces behind that overruling, which made me very happy. But it was an exception to a consistency and reliability and institutional trust, et cetera, rule, which really is exceptional. So far. Thank you. Anything you want to know? Your moment, please. You mean the slap cases?
Yeah.
Okay. The attempts to silence critics or opposition via court litigation are not yet a topic in Germany. They are of a deep concern in the European Union, and they have a directive out, et cetera, so they are reacting. But we have not seen much of it in Germany. We have seen a steep rise in aggression against politicians, new against judges. I was a victim of that myself. Compared to local politicians, nothing, but for myself, a high price to pay in office, and an experience that police and all the institutions that should protect me are not used to judges being victims of attacks. So there's more aggression in the world. There's more targeted attacks against particular actors. The courts are not safe from that anymore. We have that, but not via litigation. There is another related thing, which is political and legislative, not litigative, attempts to silence gender studies in particular. And this is quite well financed. It's internationally, globally organized. It's well resourced, and it's dangerous. And I keep saying to my academic colleagues, they start with us in gender studies, you will be next, if you're really into academic thinking. Because what is that? The right-wingers, the autocrats, want to silence all their critics. So it's the media, if it's independent, it's research in the academy, and then it's the courts, because the courts are the only ones to block them once they made it into elections. So there's a logic behind that. But again, they're using in Germany, because then it's a civil law and not a common law, they're using legislation and political strategies to date. Silencing, not as much. We only have very prominent people who try to silence the media so we don't become the UK. And they're pretty successful in doing that. But yeah, please.